Women's News embarks on its third decade as the only global nonprofit news organization reporting on the most crucial issues impacting women and girls around the world so that we may continue to shape how women and girls are represented in the media toward creating a more equitable world that honors, respects, and supports the lives of women and girls by seeking the truth and reporting it, acting independently with accountability and transparency. Thank you for tuning in.
My name is Julie Suk. I'm a professor of law at Fordham University School of Law in New York City. I'm an expert on gender equality in constitutions around the world, as well as in the United States, and author of We the Women, The Unstoppable Mothers of the Equal Rights Amendment, which is a book that details the 100-year and ongoing struggle for an amendment guaranteeing gender equality in the US Constitution. Most constitutions around the world, pretty much every constitution that's been drafted in the 20th century and the 21st century, has a provision that effectively does that, even though sometimes it's worded as equal rights between women and men, or it's worded as no discrimination on the basis of sex or no discrimination on the basis of gender. But the basic idea is to have a constitutional provision that says women are equal participants in society, have equal rights in the economic, legal, and political sphere, are people with equal stature under the law. So that's what the purpose of such a constitutional provision is. And in the United States, despite 100 years and counting of efforts to get such a provision in the US Constitution, it isn't officially in the text of the US Constitution yet.
So I have two questions right off the bat. One is, what were the women who introduced the ERA, what were they trying to accomplish? What was it they wanted? And why has it taken 100 years, and why do we still not have it?
Yeah, well, if you think about the introduction of the ERA in 1923, that was an amendment that was introduced on the heels of the 19th Amendment, which was the Women's Suffrage Amendment. And that amendment had been fought for nearly a century as well. The 19th Amendment just says that the right to vote can't be denied or abridged on account of sex. It doesn't make reference to other rights. When that movement succeeded in a constitutional amendment, many of the proponents of women's suffrage said, well, the vote is only the beginning, and the vote is not enough, because what existed at the time were many laws, both at the federal and state level, that excluded women from what we would today recognize to be the basic rights of citizenship. So, for example, if there are laws in a state that say that you can't own property if you're a married woman, or laws in a state that say you can't work in certain jobs if you're a woman, or laws in another state that say even if you can work at certain jobs as a woman, you don't own your own earnings, because all of the earnings are controlled within the family by the head of household, which is always the husband and father, right? So if you have those kinds of laws, then women do not have equal rights under the law. And so the real purpose was to, just in one fell swoop, to make it illegal to pass any laws that really excluded women from equal participation. And interestingly, in the 100 years since it was introduced, many of those laws have fallen away because for a variety of reasons, our political leaders and elected representatives have actually gotten rid of those laws. And some of those laws have been gotten rid of, not just because lawmakers have repealed them, but also because feminists like the late Justice Ruth Bader Ginsburg, when she was an attorney in the 1970s, she brought a lot of cases. She litigated them to have some of those laws that I've mentioned struck down. And they were struck down not based on the ERA, but based on an interpretation and an extension of the existing constitutional text in the 14th Amendment, which guarantees equal protection of the laws.
Why has it taken 100 years? What's the story there?
Well, we could start by looking at why it took so long to get women's suffrage. I think it's pretty obvious that when you don't have the right to vote, you're not among the people voting on whether women could vote. There's a real paradox. If you don't have power, it's hard to get power when the people who decide who has power don't include women. And I think that story is very easy to tell about the vote, but it's also true about the Equal Rights Amendment. And let me be a little bit more specific. Our Constitution, Article 5 of the US Constitution, tells you how to get a constitutional amendment. It tells you that you need 2/3 of both houses of Congress and 3/4 of all the state legislatures to ratify the amendment. And so if you exist in a space where most people who are elected to Congress are opponents of the amendment, and most of them are men. I mean, at the time that the ERA is introduced, there's really one woman in Congress at all. And for decades, there are very few women in Congress, and many of the women who are in Congress are elected in special elections after their husbands die, and they take on their husbands' seats, right? So women are greatly underrepresented. And so our rules of change, because they require such a major, huge supermajority, make it really difficult to have changes in the direction of greater constitutional inclusion.
So you're saying that structurally the system is designed to keep people from gaining power?
So I think that at the founding, our political institutions were designed to maintain a certain balance of power, what the founders had in mind. So for example, they designed a Senate that would always be 2 senators per state, regardless of the population of that state. And that's one thing that really, in some ways, overrepresented underpopulated slaveholding states. There are a lot of features of the system that kept in power a certain set of people and regions and states that were in power at the beginning and were very interested in excluding both women and African Americans from citizenship and political power.
I mean, the story of America is this story of movements and of people finding ways to navigate through this unequal racist system and claim bits of power for themselves and to change the system as they go. And I'm wondering if this story of the ERA, is it possible to tell it that way?
Yeah, absolutely. It's not surprising. The ERA really doesn't get off the ground between 1923 and the early 1970s. And I think it's just because it's not a political priority, but even if every woman in Congress had supported it in the 1920s, that would have been like a few people, just a handful of people. And even in 1970, when it does get 2/3 of the House vote, or well over 2/3 of the House vote, even when Congress adopts it in 1972, there's really like 10 women, around 10 women, depending on at what moment in the congressional session you count, in Congress at all. And almost all of them, all but one, is in favor of the ERA, and many are very active in pushing it forward, and that makes a huge difference to its popularity. Not to mention that there's a whole movement. There's the second wave of the women's movement that is supporting the ERA, by the time you get to the 1970s. So I think that you're absolutely right that part of what makes the ERA succeed is the eventual empowerment of women, and part of the purpose of the ERA is not just what you get when you put those words into the constitutional text as law, but the politics of drawing attention to the inequality of rights that exist everywhere. And that's what empowers women and empowers them not only to pursue the ERA as constitutional text, but to pursue many other legal and political changes that they think that the ERA is about.
There really isn't an understanding of what this thing is and why it's important. I think I mentioned to you that I spoke to a few 20-something women. The three things they cared about most were equal pay, discrimination, including Asian hate. Two of the women were Asian, and reproductive rights. And then they talked about other issues of harassment and pregnancy discrimination. They didn't use those words. They said things like, I don't want to have my kids until I'm in my late 30s because I don't want to be discriminated against in my job as an inevitability.
Wow. Yeah.
But then I said, but okay, so what do you know about the ERA? And they'd never even heard of it. And I said, well, what questions might you have of the experts that I'm going to talk to? And they said, well, how does that even work? Like how, well, first they just had no confidence that the system that they live in, these were three women of color and women, had no confidence that the system that they live in would ever have their back. And then when I said, well, there's this ERA that women have been fighting for that might help make these some changes that might empower you, they're like, well, the Constitution doesn't seem very relevant to me, they said. It doesn't seem very modern, was another thing. And then there was that last question of, well, how would that even work? Like, how does something in the Constitution affect my life in any way? I'd like to speak to them in understanding the relevance of what this is.
I'm not surprised by the story you tell, Rachel, because I think that many young people in America today do not see the Constitution of the United States as something that can change because of what they do. Largely, it's because the amendment rule that we have, Article 5, has been so infrequently used because it's so hard to use, because it requires such a huge consensus, that most of the constitutional change that we have gotten has come through lawyers and judges, through Supreme Court interpretation. And so most people do not feel like changing the Constitution is something that they can do to affect their rights. And that's something that's radically different from the way that constitutions work in other countries, right? So part of my interest personally in studying the ERA stemmed from my spending time talking to my contemporaries when I was in my 20s and when I was in law school in the early 2000s. My contemporaries in other countries like France, who said, well, the court struck down a law requiring gender parity in elections for public office and in political party candidate lists, equal numbers of men and women. The court struck it down, so you know what we're going to do? We're going to amend the Constitution to put gender parity in there. And they did it. They got an amendment in 1999. They got another amendment in 2008 that made it even stronger. But I don't think we think that way here. You know what? The Supreme Court has gutted reproductive rights. So you know what we're going to do? We're going to amend the Constitution. I don't think people in America think of that. They say, we're going to try to bring more lawsuits to get different judges to say something else, right? And I think that is a fundamental problem of constitutional democracy. And this brings us to the ERA. I think there was a time when women thought, when the laws are oppressive, we need to change the law. We need to change the Constitution to begin with, right? And then we need to change other laws empowered by the way in the constitutional change that we have made. We the people, we the women, not we the judges,
Right.
we the Supreme Court. Okay, so I think, so that is a fundamental problem. And so here, it's taken this long, and the story that you see is that there is not enough power. There's a tremendous groundswell in the 70s, but it comes short in ratifying the ERA. Although we have to remember, if you think about the fact that 35 states ratified the ERA between 1972 and 1977, we focus on the fact that that was not enough to send it over the edge in the US. But think about that, 35 out of 50 states, that's a clear supermajority of the states. And it's a clear supermajority of the people who live in this country who supported the ERA. And yet, in this country, even if the majority of the American people vote for one candidate for president, that person may or may not become president because we have in the Constitution the Electoral College, right? So that's yet another example of how we have structures in the Constitution that prevent the people from democratically deciding our fate. Electoral College is one example. Article 5 of the Constitution about amendments is another example. So if you think about the ERA, it's like a very strong majority of the country at different historical moments has supported it, but we have structures in the Constitution that say, but too bad, you can't add it to the Constitution. So now what do we do to get out of this cage, right? The Constitution is this cage that we've built around ourselves. It was written in the 18th century, and we're trying to use it to deal with 21st century problems, right? So I think that what the ERA brings attention to, the fact that it has not succeeded, despite the fact that it's had so much support and it's had so much influence as well, because the success of the ERA has influenced the way that we have interpreted the Equal Protection Clause. It has brought a lot of women to the streets, right? ERA demonstrations, ERA discussions in the legislatures have opened people's minds about what more needs to happen on things like equal pay and domestic violence and campus sexual assault. And the fact that women are discriminated against when they are pregnant and when they become mothers, and that women bear the brunt of caregiving in this society, all of those things, right? So I think that finishing the ERA by bringing it over the edge and having it recognized in the Constitution is a really important way of continuing the fight for empowerment, which is not in the end about empowering women or about feminism. It's really about making people into agents of constitutional change. And it's a very tall order in the United States because our amendment rule says that the people are not in charge of changing the Constitution, right? And even within the United States, you'll see some differences. Like in many states, the people do have a role in amending the Constitution. They can do ballot initiatives. Many states have an amendment rule that says that once there is an amendment that's proposed by the legislature, you need to have a referendum. People have to vote on whether or not it becomes an amendment to the Constitution. So I think that focusing on the ERA now, the fact that it's been attempted and supported and has had so much influence for over a century, but yet is still not part of the Constitution under the official rules of what makes something part of our Constitution, should tell us something about some serious flaws in the US Constitution that the people should feel empowered to address collectively. And I think we can begin by getting the ERA into the Constitution. And right now, the means to do that is to have those three last post-deadline ratifications of the ERA, which happened in the recent years, recognized. And I think the path to having it recognized is for Congress to remove the deadline and to officially then the removal of the deadline would officially make it law, or make it part of constitutional law, make it part of the Constitution. But I think doing that and having that success story would really, I think, open up a whole lot of other conversations that we need to have in this country about empowering people for constitutional change and empowering people to update the provisions of the Constitution that actually keep subordinated groups subordinated, including the Electoral College, including the design of the Senate. The design of the Senate also empowers the Senate to have its own rules that block changes that are in favor of the people, including the filibuster.
Speaking of filibusters, can we talk about this this deadline? Because it sounds really wonky, and it makes a lot of people go to sleep. And yet, both the story of why the deadline is there is fascinating to me, and also what it represents and what it would represent if we or when we're able to get it removed in order to get the ERA recorded in the Constitution.
So the deadline on the ratification of a constitutional amendment was a brilliant, or is a brilliant, political weapon that was invented by men who wanted to stay in power in the context of vast social division on important questions, namely the Prohibition Amendment. Many people in the country wanted prohibition, and some politicians didn't want to vote against it, but were ambivalent about it. So the deadline was a compromise weapon. It was a way of saying, if people really want it, they better get in line quickly. Otherwise, we'll get past it and we won't have prohibition. So give it a time limit. Maybe it'll die on its own without you having to kill it. And that's the first time that the deadline was used. The next amendment that came up was women's suffrage. And again, there were some guys who did not want to go down in history as the people who opposed women's right to vote, but they didn't really want women's right to vote to succeed either. Solution, deadline. I don't kill it, but maybe it'll die on its own, right? And the suffragists called them out on it. Carrie Chapman Catt, they said, we don't want a deadline on the 19th Amendment. Because if you put a deadline on the 19th on the suffrage amendment, then it's just going to die, and we're going to be doing this all over again. So no 7-year deadline, right? And there was no deadline on the 19th Amendment for that reason. But because it was used so frequently to achieve a political compromise in the 20th century, many people began to think that it was pro forma. But interestingly, the ERA was proposed in 1970 with no deadline, and the House passed it with no deadline. But when it got to the Senate, most men in the Senate supported the ERA, but a few very vocal opponents, including Sam Ervin, a segregationist from North Carolina, who everyone knew he was part of the group that filibustered the Civil Rights Act in 1964. So they dragged their heels, and they opposed the ERA on many substantive grounds. They did not want to give women equality under the Constitution, but one of the many arguments they made was, why doesn't this have a deadline? Almost all the amendments that we've had have had a deadline. And if you frame it like that, it looks like a pretty neutral and small procedural intervention, but they dragged their heels and dragged out debate. There's no time limit on debate in the Senate. They dragged their heels on mostly a lot of other issues having specifically to do with the place of women in the military or in the workplace. But one additional sticking point was the deadline. So the supporters of the ERA said, let's just put a deadline in. They didn't want to compromise on the important issues like what's going to happen to women in the workplace, right? But they compromised on the deadline. So when the ERA was reintroduced in 1971, and again passed by an overwhelming over 90% majority of the House and over 90% majority of the Senate, it had that 7-year deadline. And if you trace that legislative history, if you look carefully at the debates about the ERA that led to its success in the 1970s, two things are clear. Number one, the deadline got in there because of very vocal men who were in a very small minority, but really willing to make a big stink.
Were they threatening
known
a
as the
filibuster?
They never said the F word, but they were talking long and long and long and preventing the thing from coming to a vote. They were introducing all these amendments to the ERA, like they wanted to put in more language saying this doesn't mean women can be drafted. You know, they tried to put in all this stuff. These are all delay tactics, because if you change the text, that means that it has to go back to the House, right? And if you're running out of time before the legislative session ends, it's not going to go back to the House, it dies, right? So all these delay tactics are basically like a filibuster, right? You don't vote on it so that you could debate on it indefinitely. But we don't debate on things indefinitely. The congressional session ends and things that didn't get done are dead, right? Or then have to be reintroduced after elections in the next legislative session. That's how the legislative process and the amendment process would work. So the deadline was one of these things. If you wanted a deadline in, that meant that even if you voted on it, it would be the ERA would effectively be dead. It'd have to be reintroduced, because you make a change. You can't have an amendment sent to the states for ratification unless both houses have agreed to the same text, right? So these are facts about like how you make law that really matter for understanding like the end of the legislative session was coming up, and a few guys who were prone to talking for hours and hours and hours said, what about that deadline? And that's why the next time when they come back after elections, Martha Griffiths says, all right, we're just going to put that deadline in. It has overwhelming support. But I think if you look closely at the legislative history, as I have, it's really clear. The second thing that I mentioned, the second thing that's really clear from that history is that there were 8 men in the Senate who voted against the ERA. 84-8 was the vote. And it's really clear that there was enough support for the ERA in the Senate that even if it hadn't had the deadline, if it had just come up for a vote without some few people dragging out debate and preventing it from coming to a vote, if it just come for a vote without the deadline, it would have passed by 2/3, no question, right? And I think we have to understand those dynamics, the possibility of filibuster giving an inordinate amount of power to people who are just willing to be a pain, even if they don't have the votes to block something. If they can prevent it from coming up for a vote just by talking longer, they wield an enormous amount of disproportionate power. And that's exactly what happened. And then if you look at the history of ratifications in a place like Virginia, why did it take until 2020 for Virginia to ratify the ERA? Well, they tried in the 1970s to ratify it. The men who controlled the Committee on Privileges and Elections in one house of the Virginia legislature kept it bottled up in committee. They have an inordinate amount of power. Even if there are the votes in one house of the legislature to pass the ratification, if 4 guys on the Privileges and Elections Committee say, we're not sending it up for a vote, it dies in committee, right? And that happened again and again.
Even if the majority of people support it.
Right, even if the majority of people support it. But if it doesn't go up for a vote, it has to go through committee, right? In all state legislatures, as well as in the federal legislature, the whole body of the legislature doesn't get to vote up or down on anything until the committee brings it to the floor. But let's say you take a committee vote and the people who control the committee or have a majority on the committee say, we're not going to bring it to the floor. This is a story I tell in my book, which I recommend to you. In 1970, that vote everyone talks about, 96% of the House voting for it.
In 1970.
In 1970. Do you know that throughout the 1960s, it never went up for a vote in the House because the chair of the House Judiciary Committee refused, and the men who controlled the Judiciary Committee refused to bring it to a vote. So in order for it to get to a vote, Martha Griffiths had to really learn some parliamentary procedure. She did a discharge petition. Discharge petition is If the committee that has the bill doesn't send it to the floor, one person can get the signatures of 50% of the House to bring it to the floor. You're saying, even though the Judiciary Committee is in charge of this bill, if I could get half of the House to say we want to vote on it, she took 3 months to corner 200 and however many, 218 people in order to get their signatures. And that's how it went up for a vote. And when it went up for a vote, it got 96%. But this is another example of our legislatures are structured around minority power, right? The committee that has control of the vote. If it's controlled by a guy who hates the ERA, then chances are it's not going to go up for a vote. And even though if it does go up for a vote, there are 90% of the legislature willing to vote for it. And this is what happened in Virginia. It's what happened in many other states as well that did not ratify the ERA.
And so despite overwhelming public support, the deadline passed.
Yes.
And then it was extended. And you're saying that that was all procedural. That had nothing to do with the popularity of the ERA.
Well, I wouldn't say it had nothing to do with it, because part of the reason the politicians feel confident, even though they're in the minority, they feel confident in bottling up the ERA, not bringing it for a vote, or even in some cases voting against it in ratification debates. Part of the reason they feel confident of that is that there is a women's movement opposing the ERA led by Phyllis Schlafly. Although I don't think it had a tremendous amount of support, but it's a movement that's very effective at communicating with men in state legislatures. And indeed, Phyllis Schlafly herself was in very close contact with Sam Ervin, the senator from North Carolina, who had implicitly threatened to filibuster the ERA. And they shared a lot of strategies and communications around their opposition movement to the ERA. So that said, I think it would be a stretch to say it had nothing to do with the substance. But sure, I think that very often people who use procedure are able to exert a disproportionate amount of power by knowing procedure really well and using it to deploy it to support their substantive goals.
The deadline was extended and no other states ratified it, but then something happened. Something happened that tells the story of how change can happen. I'd love for people to understand how we get from stalemate to getting enough states to ratify it. Like what was the power that that people used to make that happen?
I think the reason you get the 3 ratifications by Nevada, Illinois, and Virginia starting in 2017 all the way up until 2020 is that there's a lot of momentum generated by the Women's March, which is itself a reaction to Donald Trump's election to the presidency, as well as the Me Too movement in 2018. And so much of the story is also just looking at Nevada, becoming the first legislature, first state legislature in the United States to have more than 50% women elected, and increasing numbers of women in the Illinois and Virginia legislature as well. So I think they pick up the ERA late in the game because it's a project that they think they want to finish. And if you look at the history of the battles over the ERA in the 1970s, and you understand that part of the reason the ERA lost in those 3 states in particular was because of the way in which men manipulated parliamentary rules and structures to ensure the ERA's defeat. It's kind of like there's a turning of the tide when you have sufficient numbers of women in control of committees and with a significant voice in these state legislatures to get the ERA ratified. And I think that itself, whether or not you put the text of the ERA in the Constitution, that you see those last 3 ratifications happening through that process says a lot about how far we've come, even though we still have a long way to go. And so I think what it would take now, each of these states, especially Nevada, said that the reason they were, well, it's not like they didn't know about the deadline. We all know that there's a deadline. But what they put in the preamble when they ratified was, well, they understand that Congress imposed the deadline. It wasn't part of the ERA's text. So if Congress has power to propose amendments and they put a deadline in, they also they have the same power to change the deadline, which there is precedent for. Congress changed the deadline in 1977 at a time when a very large number of women had been elected to Congress, and they started a women's caucus for the first time in Congress right around the time. And one of the things that they really embraced, and this is women from both political parties embraced this, was the extension of the ERA deadline by 3 years. So if the ERA deadline could be extended, it could be extended again, or it could just be removed. And that's what has been proposed in the House. There's enough support in the Senate to remove the deadline, but because of the Senate filibuster, it has not been brought up for a vote, and probably won't be brought up for a vote, even though if it came to the floor, you have 51 votes in the Senate to remove the ERA deadline. So I think that's what it would take. That is, you'd have to, both houses of Congress would have to line up in favor of removing the deadline.
Do you have any last thing you want to say before you sign off?
Yeah, I think it's a basic staple of modern constitutionalism to guarantee equality to women, particularly for societies that are overcoming legal orders based in patriarchy. So I think that's the most important reason why we should have the ERA, but we should think of the ERA as a beginning and a necessary condition of the empowerment of people of all genders, especially women and those previously subordinated. It's only the beginning, and it's necessary, but it's far from sufficient. And it's not the end.
Thank you so much, Professor Sook.
Good luck.
Thank you. Okay,
Goodbye.
bye.
Thank you for tuning in to the Women's E-News podcast. If you like what you've heard, please subscribe. And to learn more about Women's E-News, please visit us at womensenews.org. It's completely free to subscribe.